Today we have the privilege of speaking to the Chairman and Director of Stegmanns Attorneys, Nicole Pagel. Stegmanns Attorneys is a 129-year-old law firm, and today Nicole is going to give us some tips on the do's and don'ts of the real estate industry for real estate agents. Nicole, thank you very much for your time today. We are going to ask you to discuss a few points with regards to the do's and don'ts of the real estate industry, and just some advice for real estate agents out there as to what they should look out for. And if you don't mind just discussing a few tips for us, we'd appreciate it.
The first tip I can give any estate agent is to know your sale agreement. It seems like a silly thing to say, but there are important provisions in a sale agreement, and the sale of land is one of the most complicated things that you can do as an attorney or as a real estate agent. So you have to know your contract. You need to be able to advise your seller and your purchaser of exactly what is in the contract. Make sure your dates are correct, and make sure that your seller and purchaser knows exactly what it is that he's signing. The second thing that I would like to mention is when you take a mandate, inspect the property fully. When you go to the property the first time, pretend you're the buyer of that property. Look at every nook and cranny, look at every tile, open every tap. Make sure that you know, as much as it's not your property, make sure you know exactly what it is that you're selling. It is a massive asset, it's a lot of money involved, and it's important that when you try and sell something like that, that your purchaser knows exactly what it is that he's going to be buying, and he makes an informed decision. That will also avoid a lot of disruptions or uncertainty or arguments at a later stage in the transaction.
On that point, may I just add that it would also be important for the agent to ensure that the seller signs off on the property condition report.
Yes, get the seller to sign a condition report. It is literally the most important document. Let your seller take responsibility for everything in the house. You do not take responsibility for the house. You're selling the house, but it doesn't belong to you. So don't take responsibility for any defects. The third thing I would like to make note of is make note of all movables in the property. It may seem silly, but a Wendy house, a bird bath, a cupboard that was designed specifically for a certain kitchen, make note of it, not only between you and the seller and with the purchaser, but put it in your sale agreement. The only way to avoid property disputes is to put it in the sale agreement. So if there's any uncertainty about any of the movables, make sure what is going, what is staying, and actually list them in your sale agreement.
We especially have problems with mirrors as well, funny enough.
Absolutely. Mirrors are always an area of dispute. And my fourth point is to specifically mention all of this in the sale agreement. So specify all of these movables just as a way to avoid any area of disputes along the line. The fifth point that I've made here is to make sure, and again it seems like a silly point, but make sure that your guarantee and loan approval due dates are correct, that they are reasonable, and that they are attainable. And the only way you can do this is make very sure with your purchaser how he's buying the property. Is he buying cash? Is he taking a loan? Give him a reasonable amount of time to obtain that loan, especially if he's buying in a trust or a company or a closed corporation. Those loans generally take longer, so you may need more than the general 21 days for loan approval. So make sure that your loan approval due date is 21 to 28 days, and make sure that your guarantee due date is after that. It's amazing how many times we get a sale agreement where the loan approval and guarantee due dates are the same dates. That's impossible. Make sure your loan approval due date is 21 to 28 days, and that your guarantee due date is approximately 2 to 3 weeks after that. All right. And then make sure that your purchaser knows exactly what the timelines are, and that he is on a fixed timeline, that he needs to get going with the bond originators or the private bankers. The sixth note that I've made is with regard to alarm systems. They also cause many disputes. If you see an eye of an alarm system, ask your seller, is it connected to a specific company, a security company? If so, can your purchaser take over that system or that contract? Make sure that it's in working order. If your purchaser sees an alarm system, he is going to accept that it is in working order. So make sure of that with your seller. If it's not in working order, it's not a problem. Just advise your purchaser accordingly and put it in the sale agreement so that he knows exactly what it is that he's buying. The next point, number 7, is to mention any defects in the property in your sale agreement. Your seller is not liable to fix every defect in the property. For example, leaking roofs or cracked tiles or damp in the walls. He's not obliged to fix any of that. But your purchaser does need to be aware of it and needs to be aware of the fact that he's not going to fix it. So the biggest dispute is when the purchaser moves in, all the furniture is gone, and all of a sudden they see all these latent defects. So again, your seller doesn't have to fix them, but he does need to make your purchaser aware of them. And again, mention those in your sale agreements. That way your purchaser can never turn around and say that you didn't tell him about it. The next point is with regards to costs and transfer duty. It happens quite often that the purchaser will turn around and say that they did not know that they had to pay costs, that they had to pay transfer duty, that they had to pay a bond attorney's fees. The other alternative is that they didn't know that they had to pay that much. And we end up in the situation where the purchaser has to pay the costs over a 3-month period. Obviously that delays the transaction, the seller is very unhappy, the agent's very unhappy. So it's very important to advise your purchaser with regard to costs. He must know exactly how much it's going to cost him, and you must know that he can afford to buy the property at the end of the day, that he has the money for the costs. Transfer duty is very expensive, it's non-negotiable, it is set by SARS, there's no discounts on transfer duty. He must know that he is going to have to pay the transfer duty up front as well as the attorney's costs. You can always ask a conveyancer for a quotation if you're not sure, if you don't have a cost statement, but just make sure that your purchaser knows exactly how much it's going to cost him at the end of the day. Building plans. Building plans are one of the biggest bones of contention at the moment because the banks are asking for building plans. Your seller is supposed to have building plans, but historically everyone's bought houses, they've never asked for building plans. All of a sudden, the last few years, the banks are asking for building plans. Your purchaser will tend to not get a bond if he doesn't have a copy of the building plans. So your seller, he doesn't have to furnish the purchaser. If he hasn't made any amendments to the house, he doesn't have to furnish your purchaser with building plans. But if your purchaser buys a house and he wants building plans, there must be agreement between the parties. If your sale agreement says that the seller will provide the purchaser with building plans, the seller must know that he's signing that, and he must acknowledge that, and he must supply the building plans, because otherwise it will be an issue. If there are no current building plans and new ones have to be drafted, you're looking at an 8 to 12 week delay, not to mention 20 to 30,000 Rand in building plans. There must just be agreement between your seller and purchaser as to who will provide the building plans should the bank ask for building plans. So make sure your seller knows what his obligations are, make sure your purchaser knows whether the seller is going to provide them or not. Then the last point that I've made is that, and a lot of agents, they've heard the word FICA before, but they're not aware of what their obligations are. Estate agencies and estate agents are accountable institutions. You have to know your client. You have to FICA your client. But not only that, when it comes to your purchases, you have to know where the purchaser's getting the money to purchase the property. And that's not just to say that he's getting a bond. You need to know what he does for a living, where he's going to get the money to pay off that bond. So FICA has become a major issue in this country, and it is very important that you know your client, you know where the funds are coming from. So it is important that especially the principals of estate agents know the FICA Act, know how to report, and that they train their agents accordingly, because every accountable institution must have a FICA compliance officer, and is the principal's obligation to make sure that all of the agents are FICA-ing their clients.
Nicole, thank you very much for your time. We sincerely appreciate it. It was very insightful, and certainly, especially with the tips that you've given us, it is going to be great advice for the real estate agents out there. Something we don't always address all the time. So thank you, sincerely appreciate it, and we wish you all the best.